In other news, a popular cheese shop is shut down tonight. News Channel 5's Roosevelt Leftwich is following this story and joins us live from Sugar Creek. Roosevelt, what can you tell us?
Well, I'll tell you about it. It's only affecting one plant here. It's the Union Cheese Company that's just across the border in Holmes County. But according to the owners of the plant, they say they got a raw deal from the FDA. Union Cheese is located in the heart of cheese country here in Ohio. Now, the owners gave us a complete tour of the facility. Well, Union Cheese lost its lawsuit, and they have 1 million pounds of cheese either sitting in coolers or in an aging room that they can't sell. They say they were treated unfairly by the FDA.
Yes, it's kind of real hard. It's kind of surprising, too. One part of the government says I was okay, and the other says I'm not, so.
Now, will this shut you down?
If we don't comply with their, yes.
They're shut down now, and they haven't sent a brick of cheese out in quite a while. And the longer the process goes on, Gangale says a lot of people will be hurt. By being shut down, nobody's working, and the milk producers aren't able to sell their milk.
Correct. There's an overabundance this time of year, and it's just hard to get rid of the milk right now.
I believe there's a lot of federal questions regarding the case, whether they conducted a federal trial with improper parties named, whether Antonio C. Gangale III had an interest relating to the subject of the action and was so situated that the disposition of the action in his absence impaired or impeded his ability to protect those interests, whether Antonio C. Gangale III was adversely affected, was the prejudice immediate and serious, and whether the requisites for a valid judgment were met, whether the June 16th order was virtually impossible and or impossible, whether it violates the standards of identity of natural Swiss cheese and conflicts with federal law. Within my YouTube channel, Federal Trial with Improper Parties Named, it goes through some of the case docket, and you'll examine docket number 8, docket number 11, and docket 13, where it appears to express to the court that improper parties were named. I want to examine whether the declarations of Philip, the lead investigator, were they incorrect and inaccurate, as well as whether the declarations of John R. Moselli and M. Madden. So were these declarations before the court incorrect? An indispensable party. An indispensable party is a party to a proceeding that must be included in a lawsuit in order for the court to render and execute a final judgment. Mandatory joiner. The required inclusion of a person who is not an original party to a lawsuit but whose presence in the lawsuit is necessary for it to proceed. Was I possibly the only individual with direct knowledge with certain facts within this case? Federal Rules of Civil Procedure 12, lack of subject matter jurisdiction and failure to join a party under Rule 19. Rule 12B7 concerns failure to join an indispensable party pursuant to Rule 19. As with lack of subject matter jurisdiction, 12B1, this can be raised at any time. Compulsory joiner, also known as mandatory joiner, refers to the process of joining parties or claims without which the suit could not proceed. In Civil Procedure 19 of the Rules of Civil Procedure governs compulsory joiner of parties. This rule is intended to protect the party's right to be heard and to participate in the adjudication of a claimed interest. Here, as a practical matter, impair or impede a person's ability to protect the interest. Lack of jurisdiction recognized 2255 claims. When a federal court lacks constitutional or statutory jurisdiction, it has no power or authority to do anything. Such actions may also be attacked via Section 2225 motion. Jurisdictional defect, in fact, cannot be waived, defaulted, or lost in any way. If a federal court acted outside its limited jurisdiction, the action is void from the get-go. This lack of jurisdiction is ripe for 2255 claims. Requisites for a valid judgment. A person whose interests are to be adjudicated must be given adequate notice of the proceeding and an opportunity to be heard. There's a whole list of legal issues, I believe, in this case, United States versus Union Cheese. I believe that there's issues that this order is not possible. You'll see in an affidavit by a co-op out of New York that was supplying Union. It says, during one phone call conversation with Mr. Charles Sedgwick, he stated that it was going to be virtually impossible for Mr. Gangale to resume Swiss cheese manufacturing operations. You'll see here, surveys by the FDA have established that 12% of the ball raw milk is contaminated with Listeria mono. Further, it goes on to say that Listeria mono can also be present in cheese factories where good sanitation and hygiene are practiced. You'll see within footnote number 7, analysts by the raw milk of the Midwest showed that 13% of the samples contain Listeria. Further, you'll see in Dairy Foods magazine, USDA and FDA surveys have reported that Listeria is present in more than 10% of all raw milk in commercial U.S. dairy farms. What's concerning about this case is that the FDA and the court order required Union not to have Listeria mono or other pathogens. Is that possible? Further, you'll see that the standards of identity of natural Swiss cheese, which was the only cheese that Union Cheese manufactured, allows for raw milk or unpasteurized milk and aged for 60 days. So would it conflict with the standards of identity? Also, the Code of Federal Regulations allows unpasteurized milk to be used, and that being raw. So would that conflict with the federal court order? So is there issues that this did not comply with applicable law? You'll see here later that they will create the Listeria rule of controlling Listeria in post-lethality exposure. So here you'll see environment after it has undergone the lethality treatment. So in this particular case, they required that zero Listeria and other pathogens in the processing area to prevent contamination from occurring. Does it appear that the order that was issued does not conform with the law? You'll see further that we were approved by the United States Department of Agriculture during the disputes. So there were two conflicting federal agencies. Due process in the United States, the right to receive notice before the government deprives an individual of a protected interest is guaranteed, along with the opportunity to be heard. Were there due process violations within this case? I believe that there was deprivation of rights, and I believe that there was willful deprivation of rights in this matter. Most concerning is on 4/18/01 that I will be barred from the use of the courts. You'll see here, petitioner is adjourned from filing any lawsuits or other documents with the court. This was done without notice or an opportunity to be heard. And does it create huge legal issues if I had interest within a case and here I'm being permanently barred access? You'll see in my YouTube channel, Abridging the First Amendment Right to Petition, that goes over many of the issues within that matter. The right to sue and defend in court is the alternative force. In an organized society, it is the right conservative of all other rights, and it lies at the foundation of orderly government. It is one of the highest and most essential privileges of citizenship. I believe there's federal questions of infringing on First Amendment right. Was there immediate and irreversible sanction when I was barred access to the courts? Does it pose an unconstitutional restraint? Is it a flagrant, indefensible, and continuing violation of the First Amendment? Does it unquestionably constitute an irreparable injury? So some of the federal questions is whether Antonio Gangale had a First Amendment right to petition the government, whether I had habeas corpus rights, do I have due process rights and civil rights, and if I had those rights, and those rights were violated, does the law of this country afford me a remedy? And if they afford me a remedy in which the right was immediate and irreversible, flagrant, and the right to sue in court is the alternative force, whether the court establish the alternative. So what would be the remedy provided if there's a violation in this particular matter? I have a YouTube channel, Tony Gangale 9914, in which I have some videos that express some of the legal cases that I've been in. I believe that there's numerous constitutional violations, and I believe depriving access to the court is unconstitutional, and that I'm entitled to immediate remedy. Thank you for your time.